My name is George Parnham. I am a criminal defense lawyer, and I have been a criminal defense lawyer for over half a century, 51 years to be exact. I am board certified in criminal defense law, and I was the proud recipient of the Bar Association giving me a Lifetime Achievement Award for my advocacy in representing individuals accused of offenses. I absolutely thoroughly enjoy what I do, and hopefully will continue to do it for many more years. It's imperative that the public understand that the representation of an individual charged with an offense is what is most important in the criminal justice system. And it is my job to bring out the good traits of that individual's personality. And everybody has those good traits that need to be accentuated. They can be accentuated through a presentation, through expert testimony, witnesses that take the witness stand, having gone to the scene, having talked with the person that is on trial, having put together an evaluation, having put together a report, and that information is relayed to the jury. It's important to have the expert witness, for instance, talk in layman's terms, talk about the scientific approach that he or she has made in this particular case, but also to put that in layman's terms so that the jury can well understand what the individual is talking about. And that's the trap. If the expert witness talks over the head of the jury is not going to be able to relate to the expert testimony or to your client, who the jury will see through the expert as your client sits at the witness stand. Throughout my career, I have been involved in a few hundred murder cases or homicide cases, cases where an individual has reached death as a result of the actions of the person that I'm representing. People will say, well, how do you do this? How can you possibly represent someone that is accused of such an offense? And I politely say, not only is it part of the system, but it's important from my perspective to be able to present to a jury as forcefully as I possibly can my client's defense, and with argument and with expert testimony, hopefully the individual will be seen to have either engaged in self-defense or perhaps accident, and perhaps there's a third-party involvement which has not been touched upon by the state's offense report or the state's investigators. This is paramount importance. There is no, in my estimation, there is no more difficult nor fulfilling participation than in representing an individual that is accused of a homicide. This may sound bizarre to some, but in my practice, this is something that I relish to be able to defend individuals, and I never ask a person that I'm representing what happened. I will rely on the offense report, and when there are certain areas in the offense report that needs clarification, then I will approach my client and ask about those particular areas. But I rarely, if ever, have sat with a client and asked the hypothetical question, well, what happened in a particular homicide? That is not the way that I represent individuals.